Thank you, Mr. President. I also rise to speak on the Criminal Law High-Risk Offenders, Additional High-Risk Offenders Amendment Bill of 2024 on behalf of the Greens. In doing so, I recognise that the Greens believe that the rule of law, the protection of human rights and the timely access to justice for all people are fundamental values in our democracy. And indeed, we also share the belief in the importance of the separation of powers between the judiciary and the parliament, and for the reasons that the Honourable Michelle Lensink has outlined, I don't intend to talk about particular cases when speaking about this bill. Once again, we are seeing a bill being brought to this parliament in haste, and the parliament is being asked to make a decision on this within a very, very short time frame. Now, usually in the Greens, we are very reticent to do that, but I do accept the government's explanation that recent matter and the heinous crimes to which the Honourable Michelle Lensink referred has focused the government's mind on this issue, exposed a potential loophole, and given them a sense of urgency around this matter. So I accept that, and on that basis the Greens are comfortable with supporting the passage of this bill through the Parliament. The bill before us extends the definition of a high-risk offender to include someone who has assisted an offender. In our briefing, we were advised that the intention is not to be necessarily to be punitive, but that rather this is to add in an additional protective measure to enhance the protections that are available to the community. As I mentioned in my opening remarks, Mr. President, the separation of powers between the executive, the parliament and the judiciary is crucial to the maintenance of justice in our state. It is important that any legislation that passes this parliament reflects that separation. Even though this bill has eventuated in response to a high-profile case, as appears to be the case, the bill retains the decision-making capacity of the courts. This is a sensible approach when dealing with this issue. I do, however, want to put on the public record some of the concerns of the Law Society. Firstly, the Law Society recognises the principle that a person who is sentenced to a crime should be confident that they have served their term at the end of that sentence. The Law Society state in their correspondence that members of the Criminal Law Committee noted a general principle that a convicted person in most cases should be reasonably entitled to believe that their sentence and the deprivation of liberty that entails is to be fully completed at the expiration of their sentence. That is a very important principle in our justice system, Mr. President. But, as the Law Society recognises, there is another important principle for us to consider, of course, and that is the question of the risk to the broader community. We recognise that there is significant, this is the Greens, not the Law Society, I'm referring to, Mr. President, recognise that there is significant community concern around this matter, and that there is a need to ensure the community is protected, but also, I would argue, that is important for the maintenance of public confidence in our justice system as well. Just a quote from the Law Society's contribution. Members of the Criminal Law Committee queried how an examination of the likelihood of reoffending in this regard can be determined with accuracy so as to serve the paramount consideration being the safety of the community under existing Section 7.5. Making such a determination becomes particularly difficult in the case of a person who has been imprisoned for a considerable amount of time. End quote. The important factor here, Mr. President, is that this bill ensures that a decision remains with the courts, so the individual factors and circumstances of the offender are taken into account. The Law Society, I understand, is supportive of that approach, and indeed, again I quote from their correspondence, concerns with the practical implications of this proposal are largely mitigated by the fact that the Supreme Court of South Australia retains the authority to make decisions relating to whether or not an offender is to be subject to an extended supervision order, having regard to the factors set out in the Act. And Mr. President, in considering this bill, whilst it was in a short time frame, the Greens considered carefully the views of the Law Society, but I also read with interest the views of other people within the legal profession, in particular within the civil liberties space, and I am persuaded that this bill is worthy of support, and for the reasons outlined, the Greens will support its passage through this place.
The Honourable Spinara.